Jefferson County Court at law number 2 is now in session. The court is in session on today's date of April 17, 2024. Court has two dockets. We have the announcement docket and the motion to revoke probation docket. When I call your name, would you please come forward with your attorney? First two cases are cause numbers 23CCCR 1502, cause number 23CCCR 2550. Both cases are styled the state of Texas versus Tyreka Tennille Barnett.
She's present, Judge.
Okay.
We're here to ask for like a month or so.
Okay.
So I get the discovery.
All right. Ms. Barnett, your full name is Tyreka Tennille Barnett.
Yes, sir.
How are you doing, Ms. Barnett?
I'm fine. How you doing?
I'm doing fine. Thanks for asking. You're representing your case by your attorney Peter Doyle. Mr. Doyle, how are you doing?
Pretty fair, Judge.
That's good. And the state is represented by Attorney Haley Simmons. Attorney Simmons, how are you doing?
I'm great, Judge. How are you?
Okay. And Mr. Dahl, what is your announcement in Ms. Burnett's cases?
I need to do some more discovery so that she can make an informed decision, but it'll take about a month.
Okay, so you need a reset on the announcement docket. Could you give us a standard reset?
June 21st.
Okay, this case will be reset to June 21st, 2024. Ms. Burnett, your attorney will be given notice of your reset here in court. Once you get a copy of your reset from your attorney, you'll be free to go, and you have a blessed day. And Mr. Dahl, is this the only case you have? Only
Yes,
two
sir.
cases? You're free to go as well, and you have a blessed day.
Thank you.
Yeah, just get that to one, and they're gonna have to hold that for the folks that spend the time.
No.
Jefferson County Court of Law is back in session. The court is in session with the motion to revoke probation docket. First case is cause number M333474. Case is style of the state of Texas versus Michael Glenn Sinclair Jr. Mr. Sinclair, would you please come forward? I need a copy of the motion. Mr. Sinclair, your full name is Michael Sinclair Jr. Is that correct? How are you doing, Mr. Sinclair? Okay, like you're a little tired or something. What? Okay. Now, Mr. Sinclair, the state is represented, well, Mr. Sinclair, how are you doing? You doing all right now? You say you woke up, you worked real late last night? Okay. You feel all right? You fine? Okay. Now, Mr. Sinclair, the state is represented in this case by attorney Erica Porter. Ms. Porter, how are you doing?
I'm great. Yourself?
I'm doing fine, thanks for asking. State, Jefferson County Probation Office is represented in this case by Mr. Gary Gilliam. Mr. Gilliam, how are you doing?
Very well, thank you, sir.
Now, Mr. Sinclair, is this your first time here in court on this motion to revoke probation? Okay, now I'm going to read this motion to you. And then we'll tell you what your rights are. Now, Mr. Sinclair, in cause number M333474, the state has filed a motion to revoke your unadjudicated probation. In this motion, it alleges that you, Michael Glenn Sinclair Jr., was tried in the County Court at Law Number 2 of Jefferson County, Texas, on February 20th of 2024 for the offense of assault family violence, which is a Class A misdemeanor. The court found that the evidence was sufficient beyond a reasonable doubt to support a finding of guilt for the offense of assault family violence. The court deferred adjudication of guilt and placed you on unadjudicated probation for a period of 12 months. In this motion that the state has filed, there is one allegation. And that allegation states that you, Michael Glenn Sinclair Jr., failed to avoid contact with the victim or the victim's family member in person, on telephone, via mail, electronic mailing, social media, or through a third party, referred to the statements from the defendant and the victim's family that are attached to the administrative hearing. So if the court finds that you violated your probation, your punishment can be assessed up to 365 days or 1 year in the county jail. Do you understand that? All right. Give me some bond conditions. Now, as a defendant in a criminal case, you have a right to have an attorney. The document before you on the clipboard that's on that table is titled Judge's Explanation of Rights to Defendants Without Attorney. I'm going to go over this document with you. And it reads as follows. As a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Do you understand that option? Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Do you understand that option? Or number three, you may represent yourself. Now, you can represent yourself if you waive, that means if you give up your right to have an attorney to represent you. Do you understand that option? Now, this document further states that if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset. Reset means you will be given another court date. The case will be reset to give you time to hire your attorney. If you want an attorney and you do not have the money to hire an attorney, you will need to fill out a financial questionnaire. A financial questionnaire is a document on the clipboard, should be the last document, that is titled Jefferson County Affidavit of Indigence. Now, you would have to fill out that document, the first page and half of the second page, so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to represent yourself, that is, if you want to waive your right to an attorney and represent yourself, then you'll have the opportunity to talk to the prosecutor or assistant district attorney who's handling your case to see if you all can work out and come to an agreement on the case. Now, you cannot speak to the prosecutor about your case unless you first sign a written waiver of your right to be represented by an attorney. Now, the written waiver is the second document on the clipboard that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. I'm going to go over that well, if that's your choice, then we'll go over that document with you later. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you want to waive your right to an attorney, you may change your mind at any time and request that an attorney be appointed to represent you. Do you understand that? At the bottom of that document, in bold letters, it states defendant's choice. Mark initials next to only one choice. So if your choice is to hire your own attorney, then you'll place your initials on the first line to the left. If you have already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to ask for or request a court-appointed attorney, you will put your initials on the third line to the left. If you've already been appointed a court-appointed attorney to represent you in this case, then you'll place your initials on the fourth line to the left. If your choice is to waive your right to an attorney, that is to give up your right to an attorney and to represent yourself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name at the bottom of that document on the line that is titled Defendant, and you will date it today's date, April 17th of 2024. Do you understand?
Yes.
Okay. You can make your choice, sign and date the document.
This one, you got it?
Okay.
Mr. Gilliam. Mr. Gilliam. Mr. Gilliam,
Sir.
I was looking. Okay, Mr. Sinclair, when you were released from jail, you were ordered to have an ankle monitor, is that correct?
Yes.
Okay, now I just asked you whether or not you knew of Coach Arthur Lewis, and you said yes, is that correct? Okay, now, I think Arthur Lewis, uh, contacted me in reference to a case, and I assume it was this case. Wait, did you contact him to try to get him to talk to me about you not getting an ankle monitor? Or is your mother friends with his mother? I mean, with his wife? Okay, well, your mother contacted him. Were you aware of that? Okay. And I told him I couldn't talk to him about the case. So you wasn't aware of that. You wasn't aware that your mother contacted Arthur Lewis' wife to get Arthur Lewis to talk to me about removing and try to get me not to order you to have an ankle monitor. You don't, okay. Well, state, making that disclosure, I know it was a gentleman, he didn't say the name, but after reading the facts of this case, I kind of remember because it was right around the time that we ordered an ankle monitor on the gentleman. I think this is a gentleman. Now, state, do you have any objections with me continuing to be judged on this case? Do you think there's a conflict of interest or an appearance of impropriety?
No objection.
No objection, so you waive any conflicts?
Yes.
Okay. Now, Mr. Sinclair, I don't know, it seems to me, I'm not gonna go over the facts of the case, but under no circumstances should you or anyone else contact me regarding your case, other than your attorney in open court. We can talk about your case then, okay? All right. Now, Mr. Sinclair, I'm gonna give you some bond conditions. And you're gonna get a copy of these bond conditions. It states standard bond conditions in County Court at Law number 2. Following return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition? And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go to any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Now, condition number 4 doesn't apply because that only applies in the DWI case. Condition number 5 does apply, and it states that the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? And condition number 7 states that, oh, you know what? Hold on a minute. I'm looking at bond conditions already here. You didn't get a copy of bond conditions when you were at the jail?
Yes.
You got a copy? Okay, we're gonna give you another copy. What I was just reading to you were the bond conditions. Now, the other condition, I think that they wanted to talk about, where's the state? I think one of these conditions in here dealt with home confinement. The defendant shall submit to home confinement and electronic monitoring. Let me do this here. you shall, home confinement, this shall submit to home confinement and any electronic monitoring at your residence under the supervision of Janice, interlocking monitoring with notification to the victim if the defendant is at or near the location of the defendant and has been ordered to refrain from going to or near. Do you understand that condition? Now, I understand that you do work. Is that correct? So, not state, but probation, normally if they have home confinement, they are allowed to work?
Yes, sir.
Okay. Now, you are allowed to work. Okay. And you're prohibited from, I said you're prohibited from possession of firearm or ammunition unless you are a peace officer as defined in section 1.07 Texas Penal Code, actually engaged in employment as a sworn full-time paid employee, and you shall, condition number 5, you shall wear a global positioning monitoring system device attached upon release from jail, and you do have one, and so you need to continue to wear that. Okay? All right, now if you violate any one of these conditions, your bond can be revoked. If your bond is revoked, the warrant will be issued for your arrest, and you'll be placed in the Jefferson County Jail. Do you understand that? All right. So I have here a document that is titled Judge's Explanation of Defendant's Right to Defendants Without an Attorney. You recognize this document?
Yes.
Is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state that you would like to have your case reset to hire your own attorney? Now, before you sign and initial this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay. Mr. Sinclair, your case is going to be reset to give you an opportunity to hire your own attorney. Once you get your reset, and we also want to give you a copy of the bond conditions that the court signed on March 12th of 2024. All right. Please have a seat in that first chair by the water. And we're gonna have to put his name and the clause number at the top. And give him a copy of these bond conditions. Well, okay, but hold on, I'll print it. I'll print it from here. Hold on a minute. Yeah,
May I approach on, Ms. Jones, we have a plea ready on
I understand. I'm trying to get to it right now.
that? 4 people over in drug court.
Okay, well, you over here now. Jefferson County Court at Law number 2 is back in session. Court is in session and calls number 23 CCCR 1784. Case is style the state of Texas versus Ann Jones. Ms. Jones, would you please come forward?
Yeah, she kind of hard of hearing, Your Honor.
Oh, okay. Okay, this is cause number 23 CCCR 1784. Case is styled the state of Texas versus Ann Jones. Ms. Jones, is that your full name?
Yes, sir.
Ms. Jones, would you please raise your right hand? Ms. Jones, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes,
Ms. Jones, you may put your hand down. How are you doing, Ms. Jones?
sir.
How are you doing?
I'm fine.
You fine?
Yes, sir.
Okay. Ms. Jones, you're representing your case by your attorney, Attorney Kevin Lane. Mr. Lane, how are you doing?
I'm fine, Your Honor, thank you.
That's good. Mr. Lane, do you waive a record with Ms.
do, Your Honor.
Jones' case?
We do.
Ms. Jones, I have before me a document that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, Ms. Jones, it alleges that you, Ann Jones, on or about October 3rd of 2022, while you were operating a motor vehicle in a public place in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated. Second, now state, are you abandoning the enhancement paragraph?
We are.
Ms. Jones, the state is abandoning the enhancement paragraph. What that means is, instead of being charged with a Class A misdemeanor, you'll be charged with a Class B misdemeanor, which is a lower or lesser offense. Do you understand that?
Yes.
Okay, now, Ms. Jones, to the Class B misdemeanor offense of driving while intoxicated, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you are guilty?
Yes, sir.
Okay, now, Ms. Jones, I also have before me a document that is titled Misdemeanor Plea Admonishment. Do you recognize this document?
Yes, sir.
Okay, on page 2 of this same document, there are 2 sets of initials. One set is your attorney's initials, KSL, and the second set, AJ, are your initials. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes.
And on the next document, that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement?
Yes.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes.
Ms. Jones, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes.
And did you read and understand everything in these documents?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Ms. Jones, are you a citizen of the United States? State, I have before me State's Exhibit number 1. State, would you like to offer State's Exhibit number 1 into evidence?
Yes, sir.
Any objections?
No objection.
No objections. State's Exhibit number 1 will be admitted. Mr. Lane, you advised and counsel Ms. Jones, is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
And Ms. Jones, your attorney, Mr. Lane, has advised and counseled you. Are you satisfied with his representation?
Oh, yes.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Jones, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Judge.
And what is that agreement?
In exchange for the defendant's plea of guilty, the state has offered 180 over 2 years probation, 100 hours of community service, a $1,500 fine, interlock, DWI intervention, and we're gonna allow her to plead to the lesser included of DWI first.
Hold on. What's the court cost in this case? $392,
Yes.
and, yeah, $100, yeah. That's 2 years. That'd be 1440. Yeah, calculator. Thank you. Ms. Jones, the state is offering that you serve 180 days in the Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail because you will be placed on probation for a period of 2 years. During the 2-year probationary period, you'll be required to pay a DPS fine of $100, a standard fine of $1,500, court costs of $392. You'll be required to pay a probation fee of $60 a month, urinalysis fee of $15 a month. You'll be required to pay a reimbursement fee of $15. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, the total amount that you will be required to pay each month while you are on probation is $166 a month. Will you be able to pay the $166 each month? You will? Okay. You will also be required to perform 100 hours of community service. You'll be required to have an interlock device installed on any vehicle that you own or operate. And you'll be required to attend and complete a DWI education class, have an alcohol assessment, and you'll be required to adhere to the other standard terms and conditions of your probation. Ms. Jones, do you understand the state's offer?
Yes, sir.
Do you think the state's offer in your case is fair and just?
Yes,
And do you accept the state's offer?
yes.
Ms. Jones, I'll follow the people are in agreement that you've entered into with the state. Ms. Jones, you're gonna stand, you ready for it? Just have a seat and wait for the court coordinator to call your name. When you call your name, you're gonna come up to a window, follow the directions of the bailiff, and then you'll be free to go. And you have a blessed day. And Mr. Lane, you free to go and you have a blessed day.
Thank you, Your Honor, very much for.
Thank you.
Okay.
You don't have to wait for it. I'll call you right back up. Well, I said, just the last. You guys all that. You didn't. It's gonna be very. Yeah. Oh, he's just really nice. He's in charge of that.
Yeah.
Even though I don't know. Oh, shut up. I did say. I know who knows.
July 6th. Yeah.
I see that. I go through that. Yeah, I think they knew it's time for me, so I don't know. Yeah, it was something like that, you know. Yeah. I guess you know, I think, you know, it is. Yes, I think that's something that is not that much different. It's not that we do. I don't know.
We, Okay. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 23 CCCR 2340. Case is style the state of Texas versus Dorothy May Galloway. Ms. Galloway is appearing via Zoom. Ms. Galloway, you can take your mic off of mute.
Yes, sir.
How are you doing, Ms. Galloway?
I'm blessed in you.
I'm blessed as well. Thanks for asking. Ms. Galloway, you're represented in your case by your attorney, Charlie Rojas, who is also appearing via Zoom. Mr.
Yes, sir.
Rojas, how are you doing?
Doing well, Judge, thank you.
Mr. Rojas, what is your announcement in Ms. Galloway's case?
Judge, I would ask that this case be reset along with her felony. I think she's got a felony. My understanding is it was set this morning, but it's been reset. We have an agreement, Mr. Hubin and I do to dismiss this case with a forfeiture once that felony is taken care of.
Okay, do you know the reset date?
I do not know the new date, Judge.
Okay, the court coordinator just looked it up. It's May 6th.
Okay.
And so on that day, Ms. Galloway, your case is going to be reset to May 6th. So on that day, you need to go to the felony court and then come. You come here and then go to the felony court and then come back here so that this case will be disposed of once that case is disposed of. So Mr. Rojas, your reset will be sent to you. Ms. Galloway, stay in contact with your attorney and your bondsman because they will receive your reset. Thanks for being patient with us. You're free to go and you have a blessed day.
You too, sir. Thank you.
And you're welcome. And Mr. Rojas, you are also free to go. Your reset will be sent to you and you have a blessed day.
Thank you, Judge.
You're welcome. Jefferson County Court, Law number 2 is back in session. The court is in session and calls number M 377. Case is filed the state of Texas versus Wanda Michelle Turner. Wanda Michelle Turner was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., the court's bailiff called the name of Wanda Turner at the courthouse door. Wanda Turner did not answer. Wanda Turner has not appeared in court since the court has been in session. Wanda Turner's attorney, Ms. Perazzo, was here, and she stated to the court that she talked to Ms. Turner this morning, was expecting Ms. Turner to be here. And she called Ms. Turner back after she didn't appear, and she didn't answer. So the time now is 10:30 a.m. on today's date of April 17th of 2024. Ms. Bailiff, would you call the name of Wanda Turner at the courthouse door?
Wanda Turner. Wanda Turner.
She was here earlier. Yeah, Mr. Lodge was here earlier. She's talking to somebody.
Oh, it just reset, so. And the park is she's door.
She's here.
Oh, well.
Her lawyer just left.
Oh, well.
Right, she should be gone. I don't know her number to call.
She has a number. You have a cell?
Because I mean, I see this young lady that was with her sitting out here
Mr. Ellis, this is cause number N 321-394. Case is styled State of Texas versus Chase Wade Ellis. This is a case that's on our motion to revoke probation docket. Mr. Ellis, last time you were here, your case was reset 1 week for you to pay the fines and fees, and I think if it would have been paid, the state was dismissing the case. Is that correct?
No, sir. I did not.
Yes, sir. I tried to tell him out there in the hallway that, he gave me a piece of paper last time we were here that allowed me to go pay my community service also.
Right.
I went and paid everything but that this morning, and I don't have a piece of paper to do that. So I've got the money to pay it, but I don't have a piece of paper to do it. So
You didn't pay everything that you.
let's say $400 and something this morning.
It wasn't.
To my knowledge, it's everything except the community service, which is $240, right?
No, you showed me a receipt, you still have a balance with probation.
Could you, is there any way you can find that information out?
You have the sheets that you gave.
Okay. Okay, just hold on.
Outstanding balance. 127.
So my figures were wrong this morning, and I paid what I thought the supervision fees were.
Okay, so he paid 402 this morning. Is that correct?
Yes, sir. I thought the other day we had said 640 was the total amount. Is that correct?
Do we know?
Oh,
We gave him an amount?
yes, sir. We made an agreement based on what he was saying, but we made that agreement several times and he hasn't told the truth. He hasn't done what he said he's gonna do. So,
No, let me ask you this.
Oh.
So what did we tell him the last time? Did we tell him his balance was,
he told me the last time before we came into court that he was willing to pay, that he had all the money and everything
okay,
was fine,
understand,
that he was willing to pay everything that day.
understand.
And that we would also give him the paperwork to go do his community service to pay that off, that would at his request. So I gave him all the paperwork and he said he was gonna do it that day.
I understand he didn't do it that day.
Right, but
But my question to you is, what did we tell him he's saying that we told him the amount was 4 something.
640 total.
Yeah, I
But-
remember 6 something. I just got some.
But the 640 was included the 240 hours to pay off the community service.
Yes, sir.
Is that correct?
Yes, sir. I would have paid the community services more than I
I don't think, did I write it down?
the amount he was given for was 527 is what he was told last week that he owed
Yeah,
on probation fees. And then additionally. he would-
And then there was 240?
right.
Okay. So that's why he's 127 behind.
I wouldn't have not let that, knowing that they're gonna dismiss it, I wouldn't have let that,
Let me ask you is this, based on what you've been saying, you kind of suggesting that you have the 240 to
yes, sir.
pay the community service. Is that correct?
Yes, sir, I have it on my credit card, but.
Let me ask you this here.
Yes, sir.
I mean, okay, so you say you have it on your you've been paying this off your credit card?
No, sir, I'm supposed to go get it for my community service, I'm supposed to go get a gift card
Oh,
and from the HEB, and, but I've gotta have a paper to bring it in,
to bring it into HEB or?
to bring it into the probation, office.
You can't get a gift card or credit. It has to be done.
And that's what I'm saying. I would have to get the cash off
Yeah,
the
you have to
card.
get cash. You
Yeah.
can't get
So you get the cash off your card, you get the gift card. And well, you would have the paperwork from the probation office, and you could pay off the 240 that way.
Yes, sir, and that sounds
That's
like I
it.
have an additional,
But you still leave a balance of 127. Let me ask you serious. Do y'all take credit card?
At the probation office, yes, sir.
Do you have enough money on your credit card to pay off the 127 as well?
yes, sir. I've got enough money to pay, plenty enough money to pay it today. I just wasn't, I lost a piece of paper. It was the whole deal. And I guess we were here last time, I thought it was 640 or so.
Yeah, okay. So stay, what y'all want to do?
Yes.
Hey, Mr. Gilliam?
I think that probation is tiring, out with the excuses. We can give him a short, very short
No, I'd love for him
to pay
to
the.
do what he says he's gonna do, and we can be done with it. We'll go wait another week. Or.
You want to do a week?
This- I-
Or if you want to do it today?
We can do it
Yeah, he
today.
can do it
I would
today.
rather do it today, Your Honor.
Yeah.
So I get this, I'd like to get behind.
Okay. So how much time will it take for you to go do what you need to do to get the, it's 11, yeah.
Is there anybody I could have till, I think I'll probably close at 4:30.
Well, I don't know what time y'all,
What time? Time's off.
it's gonna take you that long to, I guess, to get the gift
Yeah.
card?
My credit card's in my ride, which, my girlfriend dropped me off. So
Okay.
I get her to come get me.
I understand. So she comes to get you, you got your credit card there. You can go get the money off your credit card, get the gift card, and then go to the probation office to present the gift card to them to pay off the community service. And then at the same time, you can pay the 127 over there as well. Okay, so I mean, that doesn't gonna take 5 hours to do that, huh? Because I mean, it's,
11 o'clock, y'all don't even. they break-
yeah, but I mean, you could be doing that while they breaking for lunch.
Yes, sir.
That's what I'm saying.
And I can do it in probably 3. I don't think I can get it done in any less than 3 hours. I mean,
That's
I've
2
gotta go-
o'clock.
I've got to go to HED on.
Okay,
Major.
so we'll give you the 2 o'clock. Okay, so we can give you the 2 o'clock,
That's fine. You stay.
okay? And Mr. Gilliam is gonna report back to the court whether or not, now you need to, if you don't have it done by 2 o'clock, you need to be here at 2 o'clock.
It would just be.
Yeah, you just need to be here at 2 o'clock.
Yes, sir.
Okay? Okay,
No, that's cut me. If I've got to be back here by 2, I've got to handle that for the probation
Sir,
officer.
you told us you were gonna do this exactly last week,
Yeah, 3 hours though.
and we've
So-
been dealing with this.
To
since
make
August.
it there, and I just want to make sure I'm not setting myself up.
No, you
for
got-
failure again here. Got to make it back over here.
The other thing.
as you're acting like you have to, okay. Let's give him the 3 o'clock, that's it,
Yes, sir.
okay,
That's fine.
3 o'clock, back here,
Yes, sir.
all right. Okay, so this is cause number 23 CCCR 0381, case of South State of Texas versus Trevor Joseph Stratton. Mr. Stratton, would you please come forward? Mr. Stratton, how are you doing?
Pretty good, sir.
Oh, that's good. Mr. Stratton, you're representing your case by your attorney, Ralph Kimler. Mr. Kimler, how are you doing?
Well, yeah, I think
Mr. Kimler, what's your announcement in Mr. Stratton's case?
Mr. Stratton's advised he desired a trial as well.
Okay.
What do you want to do?
I reset, if I come see the evidence Friday, if you told me to,
Okay,
Well, you said you couldn't come and see.
I'm gonna try to find a way.
okay,
He needs to look at the discovery.
okay. No problem. We're gonna keep it on the announcement docket. If he just needs to look at the discovery, you want,
I swear the court wants to do it.
okay,
2 weeks.
okay. We could get the nearest
There's announcement.
announcement that's available. What is that? June 21st? Okay.
See you Friday.
This case reset to June 21st. Your attorney's gonna get your reset. Once you get your reset from your attorney, you're free to go. Thanks for being patient with us. Now you have a blessed day. You're free to go. Well, you're gonna get his reset? Yeah, just stand right there. She'll give you a reset. You're welcome. All right. There you go. Right. She was gonna give you that reset.
Yeah, you can.
Okay, great.
All right, she's gonna be. Go Friday.
Actually, who's handling that case? The one, right?
It's his office.
So no fine.
Well, I think that's just everybody fine. But I haven't had.
Okay.